Good afternoon, ladies and gentlemen. May I request everybody to kindly settle down, please, and also request all the speakers to kindly come on the dais, please. So we're talking of merger and acquisition, so we are merging two sessions together. Well learned. The lessons of the first technical session.
It is basically application of what.
Yeah, application, exactly. Exactly, that's very important. May I request everyone to kindly settle down, please. So, without any further ado, I'll request Mr. G.P. Madan to kindly be our session chair and please start the proceedings. Over to you, sir.
Thank you, Dr. Jatinder. Welcome back, dear participants. Now we are going to, actually we have decided to merge both the technical sessions. First technical session post tea break was on the CIRP process, role of NCLT and NCLAT in that. And the next one, applicability of section 230, that is a compromise or arrangement in case of liquidation of a corporate debtor. What are the practical issues and challenges? First of all, I'm going to start this session on CIRP. And though now we have merged the session, so all the participants are, all the panelists are allowed to interject or intervene on any of the issues. Yeah. But keeping in mind the timelines, because it's already now 1:35 and I propose to end the session at 2:40. I think itne mein kafi hum apni baat kar payenge. And in this session, one thing we need to take care that infrastructure issues and the members issue has already been dealt with in detail since morning. So those issues we are not going to discuss. The number of members are come. There is a delay happening because of adjudicating authority. Infrastructure is not there. No, we will not discuss. And moreover, we are not going to the details of the issues at the level of COC and all that. What we have to going to deal with here is issues relating to concerning CIRP with respect to the adjudicating authority only. We need to travel beyond that. Otherwise, the CIRP issues we can discuss for weeks together. Everybody, all the panelists are so experts and experienced. So I would like every speaker to speak for 10 minutes. And then at last 10-15 minutes, I want to throw open for questions and answers because I'm expecting number of questions from the participants. M&A, all the participants are not dealing in M&A, but majority of you are dealing in CIRP. And some of you are having issues in liquidation also. So my first speaker is Mr. Anil Kohli. Sir, over to you.
So
if you want to speak from there,
the
choice is...
I think we should actually try to sit here only because in case we try to
Sir,
go to the mic.
I'm leaving it to the wisdom of the faculty.
Otherwise, like, it may take a little longer time. Because see, like we are 6 altogether. I think
मतलब
sitting
खड़े
here
होके बिठाना मुश्किल है. अगर खड़े
होके बिठाना मुश्किल है. In between.
यहाँ से माइक छीनना भी आसान है.
और वही मदान साहब साथ में बैठे. So good afternoon, everyone. So regarding CIRP, I won't say much because everyone is aware of that. It's a corporate insolvency resolution process. And I would say, yeah, this is the best possible mechanism for a company which is a going concern, a running company. So here I am specifying for a running company because you know what has happened, why I think there are so many issues which are arising in this IBC which we are all talking about, that there are definitely you know some things which need to be corrected to make it more you know successful and more in the direction of achieving its goals. What I feel is that first of all, there should not have been such a you know immediate enforcement upon each and every company with such a small amount of 1 lakh of a default and all. So which has created a you know the number, the volumes which are difficult to handle with this infrastructure. So I won't speak about the infrastructure. So NCLTs definitely are overburdened. So that is one thing. However, one more thing which comes to my mind to enlighten the burden from the adjudicating authorities, which what can be done is some of the processes are unnecessarily going to be to the adjudicating authorities, like filing of progress reports. This doesn't need to go to the adjudicating authority. There is nothing for adjudication before them. So, and replacement of resolution professional. Fine, admission of a process is one thing which can be decided by the adjudicating authority. Liquidation is another thing, approval of a resolution plan. So certain, these kinds of issues definitely need interference of adjudicating authority. But these administrative kind of things, extension of time and replacement of RP or, these progress reports, these can be handled by IBBI also. So this is one way, I think, which can be proposed to lighten the burden of adjudicating authorities, and it's additional to what we are talking about, the infrastructure. Second, because Mr. Madan has limited our role to speak only about the adjudicating authorities in CRP process, then comes section 19.2. Section 19.2 is the, I think, most largest volumes with the adjudicating authority. So what happens is, this comes from another cause. The cause is because the RPs, they do not find any, recourse, any kind of, I would say a kind of, respite from any direction. What they would see is only to look towards the adjudicating authority for addressing their concerns. Because, once you do not do that, so what happens is you would be called upon. What action did you take? When the issue was before you, the directors were not cooperating or the management was not cooperating, like why you have not finalized the accounts, fine, you file a 19.2 because the directors or management did not give you the information. Like in one of my matter, CBI questioned me for this, that, okay, where are the books of accounts of the earlier periods? So, sir, I said, I do not tick mark each and every document and say that, okay, I have taken into custody for, following vouchers or the books or all this. Fine, this is with the, as it's a going concern, it's a running 5-star hotel. So fine, it's with the management, it's definitely must be there only. I want tick mark. But he says, no, you should have called upon all this. And where is the 19.2 application? So fine, I said, okay, nice. What I did is I sent a mail to the management. Fine, I need all these records, last week itself. So fine, I filed a 19.2. So your concern is addressed. I am also now feeling relaxed. Okay, fine, you needed a 19.2. It's there. So this is actually adding to the burden of the adjudicating authority. So some things need to be, the entire stakeholders here. To enlighten the burden of adjudicating authority, the stakeholders need to be educated. They need to be educated like the promoters, directors. What would be their role? So they generally shed away themselves from all the responsibilities, and they would say, fine, now the RP is the whole and soul in charge. RP has to look after each and everything in the company. So we don't have anything to do with, even, the regional director is going to give you notices for even for prosecution proceedings and, asking for all informations, like you are the person. Even in MCA, they didn't know that, RP's directors are still duty bound. Only the powers of the board of directors are suspended, because they are telling me, okay, they are suspended now, so you are the person. No, the directors are not suspended. So if these people are educated and they know, yes, specifically this is their role and they have to cooperate, and what all cooperation and what will we see, the RP himself cannot run each and everything like business or, running of the, taking care of the compliances, running of the process from claims, invitation, resolution process, then each and everything. So there should be a role defined at least for, the management, what they have to do, what is, how they have to, continue, because they will say, okay, this is the loss in the business, you are responsible, the RP is responsible. No, you can only supervise, you cannot do each and everything. So what happens is now RP calls for their cooperation, and they say, no, we are not in the role now, so we are not at all accountable, so the RP will file a 19.2 application. This adds to the burden of the adjudicating authority. first of all, the role of the management, ex-management, I would say, or we should say management. They are not suspended. Management is still there. They have to run the business. RP will only play a custodian role or a supervisory role. So first of all, them, then the authorities. The most of the 19.2 or the claim rejection or all involvement of RPs comes from the taxation or the government authorities. They would keep on filing something with you and asking. They should know. So what would happen? What is the process they have to take care? How the assessments will be carried out? How they will enforce the penalties? They are just putting on penalties like adding on whatever as per their wishes. So they need to know that yes, this is the way they should run out. These people should also be educated upon what is their role. So there also some volumes will go, low from for the litigations to the adjudicating authority. Then the COC. So the creditors themselves, even the RP sometimes doesn't know, about the claims. He will say, okay, fine. One way you are just collating the claims. How to deal with, like bank guarantees or the FDRs which are kept as margin, and what will be the creditors' role in approvals for certain things. Then there is a litigation about that. So these kinds of things also, this COC also needs to be educated. And I think this all comes from the concerned authorities like RBI, not IBBI cannot enforce anything upon this kind of stakeholders. The taxation authorities, it should come from the CBDT or their regulatory authority. Regarding the stock exchanges, it should come from SEBI. And regarding the COC, it should come from RBI. So this definitely needs to be taken care that all the stakeholders are educated so that there are least litigations, and which can definitely decrease the burden from the educating authority. Then comes, about, I would say, I cannot speak about the infrastructure. That would definitely there. Then 92, I have to restrict myself to that way. So then comes the resolution plan approval. What I see in the end of the day, adjudicating authority has to just take, it's taking on record, I would say. They would definitely say the plan, since Supreme Court has also ruled that it is the commercial wisdom of the COC which would prevail. So the adjudicating authority should take time involvement in the plan approval process as per, I think, in the light of that judgment. And they don't need to, I think, go deep into all that. And this can be, adjudicated upon as at a faster pace. So this is one thing. Then admission. Definitely, they should only look for the default, and that okay, it's not my domain to educate them, but I think certain these kinds of things is required to train or educate all the stakeholders, which would definitely reduce the possibilities of litigations. With this, I'll end my 10 minutes.
Thank you.
Thank you.
Thank you, Anilji. You have said that in some of these application 19.2, progress report, replacement of RP, extension of time, they should not go to the adjudicating authority. Where should they go? IBBI. I think IBBI, you are going to give the regulator the adjudicating powers. I think this may be a dangerous situation also.
There is no adjudication required in all these processes. They are just
Registrar of NCLT. अभी तो registrar भी नहीं है वहाँ पर. And I tell you, looking at the disciplinary proceedings which have been initiated by IBBI against the insolvency professionals, in my opinion, filing of 19.2 application and filing of avoidance application should become a ritual. If you do not file it, you will receive a show cause notice from IBBI. That's why have you not done so?
That is what is increasing.
And now you want those should be filed with IBBI only.
No, not 19.2. Not 19.2.
Okay.
19.2 is to be with adjudicating.
And as far progress report is concerned, some adjudicating, some benches are accepted or taken on record with subject to just exceptions. And some benches are going into details of these progress report. And that is also actually taking a lot of time.
Recently, there is an amendment where the progress report has to be filed in an application.
Again, no, but even as on date, there are divergent practices before various benches, whether it should be filed as IA or otherwise. Filing as IA, there is only one concept, one reason, that along with IA, you deposit an amount of 1,000 rupees. That is the only thing. So they should make it mandatory along with the progress report. You'll deposit a fee of 1,000 rupees. But for that you need to change the NCLT rules also. Okay, there are other issues also, but I'll restrict my views on this. Now I invite Mr. Anil Goyal, Chairman, Triple Insolvency Professional LLP.
Thank you, Mr. Madan. I think we have to restrict to whatever has been told by you to remain, like what are the difficulties that we are finding before adjudicating authority in CIRP or a resolution plan. So what my understanding is that in case we look at the objections which has been filed by various stakeholders against a resolution plan, that would be right thing to discuss by me, because I think other things have already been spoken by Anil Kohli. So I think the conditional resolution plans is one thing which is objected, and we are all very careful that the conditional resolution plan should not be submitted. However, in the case of this airlines case, Jet Airways, this was the first resolution plan which was admitted as a conditional, because one of the condition that the license of the airlines that would be renewed, that was a condition, and that was admitted by the NCLT. So similarly, we can assume that if the resolution is depending upon a key issue, that key issue can actually be made as a condition. So that should be acceptable to the adjudicating authority. Then the resolution has to be compliant to all laws. Nobody can say in the resolution plan that in future there will be some waivers or some exemptions from GST, from any local laws, or from any income tax, as we used to do in BIFR. So that kind of options are not available in resolution plans. See, the biggest dispute that we have seen so far is from the dissenting creditors. Because see, the dissenting creditors are saying that my liquidation value has not been provided in the resolution plan. The reason being, the dissenting creditors say that I have a security interest on an asset, and the value of that asset is X, and I have not been offered that X value. That is my objection. And yes, I think this issue is actually pending before Honorable Supreme Court, that in the case of Technology Development Board versus Kotak Mahindra Bank or Stressed Asset Fund. And this issue is like whether Section 53, the interpretation of Section 53 is whether the priority of charges and the value of security interest would be considered while allocating the liquidation value or while allocating the proceeds of realization of assets to the stakeholders. So this is a very important, because so far this has not been resolved. That is my case, because originally this is the only case in the country where the allocation was done as per the Insolvency Law Committee report dated 26th of March 2018, and also based on the Supreme Court judgment in 2005, Sidco Leather versus ICICI Bank. So based on that, adjudicating authority at Ahmedabad, they gave us a positive order. However, NCLAT said that in Section 53, we could not find any category. So it is only one category of secured creditor. We could not find any category for the first charge holder, second charge holder, or subservient charge holders. We also could not find any special category where the value of the security interest has to be considered. So while the dissenting creditors say that I am entitled to the value of my security interest, the resolution applicant or even the COC says that it will be allocated as per Section 53, which is the NCLAT judgment in the case of Technology Development Board versus Anil Goyal. So this is the present dispute which is prevailing, and in most of the cases, the dissenting creditors are not getting their dues, which is equivalent to the value of their security interest. So this is also one of the difficulty that we are facing in resolution plans during CIRP. In various real estate cases that we have seen, the difficulties are regarding the delayed submission of claims by the home buyers. So all these delayed claims, like we have seen, hundreds of applications are filed after the resolution plan is approved by the Committee of Creditors. The adjudicating authority is not inclined to reject all of them because that is their hard-earned money and they have given money to the builder. So in case they have not submitted their claim, it is very difficult for any court of the country that your 50 lakhs is gone and you will get nothing now. So that is, in fact, I did a webinar on delayed admittance of claims, and I actually analyzed various judgments. So I saw that there are positive judgments when there is a case of class of creditors, maybe debenture holders, deposit holders, or the home buyers. There is a positive judgment, and it is a directions to, always there are directions to RP to admit their claims. And there are negative judgments as far as the operational creditors are concerned, but there are still positive judgments regarding the government authorities. Because see, I analyzed various 20, 30 cases where the delayed claims were filed. So in case we try to understand the operational creditors, it is easy to reject. The government authorities, the NCLT, the adjudicating authority says that you, as RP, you should have seen the litigation, you should have seen the books of account. There may be some provision made in the books of account. You should have admitted according to this. So what now we've started doing in the real estate cases, that in the resolution plan, we also make provision for all those who have not submitted their claim. So we are actually saying in the resolution plan, to avoid such kind of litigation, that even after the resolution plan is approved, in the next 90 days or 180 days, whosoever will file their claim, those people, those claimants will be treated like this. So with this paragraph, now we are thinking that all these litigation actually can set to rest, and it is very easy for the adjudicating authority to say that already it is provided in the resolution plan, you can file your claim now and you will be dealt with as provided in the resolution plan. So then the other case, which is the land owning authorities like Noida, Greater Noida authorities, they actually have been objecting to the resolution plans where they've been considered as operational creditors and the value offered to them is much lesser. So that is also a case that we fought tooth and nail, and my partner's name, Anand Son Badra, is the case name. And in the case of Shubh Kamna Buildtech, Anand Son Badra, that is the Supreme Court finally decided that Noida Authority and Greater Noida Authority or any kind of land owning agencies who have given the land on lease, they would be operational creditors. But there is a separate issue now where the land is not owned by the corporate debtor and it is a joint venture between the landowners and the corporate debtor. In those cases also, NCLAT has given a judgment that the landowners, in case they enter into a joint venture, they are rather partners, they are rather promoters, and they are not creditors. That also has been given. However, when IBBI gave me the responsibility to go and provide some kind of understanding amongst the Noida Authority and Greater Noida Authority, so I took various classes, and the consensus which is now coming up is, and even this another urban conclave happened at Gurgaon, where most of the builders and most of the RERA chairman authorities came. So now which is something which is common, is that we should consider the landowners, we should also consider the secured financial creditors, and we should also consider the home buyers. So these are the three key stakeholders in a real estate cases, and then we should try to do an arrangement amongst all of them. Otherwise, this litigation would continue, and this would never end. That is the consensus. Even authorities are also saying that, yes, this is the right way, that in case all three can sit together and do this. Then the questions which are being asked by the adjudicating authority, that in case the resolution applicant is offering some amount in the resolution plan, the adjudicating authority is saying that identify the resources, how would you make the payment? Because most of the contraventions of resolution plans are happening because the resources were not seen by the by the COC, and finally the resolution applicant could not arrange funds. So the adjudicating authority is insisting that you should provide us some satisfaction that the resources have been identified. And the other thing which is being asked by where is the recording of the committee of creditor where the committee of creditor has considered the feasibility and viability. And also at some point of time, they are asking, where is the business plan? How would you revive the company? So in most of the resolution plans, please make sure that the feasibility and viability, there should be a special note in minutes, or if not, then there should be some business plan also. In some of the adjudicating authorities, I have also seen how you are in the resolution plan, how you are attending to the cause of default. The basic cause of default has to be attended to and how it has been dealt with. So that is also one of the issue that has been considered. In few cases, we have seen where the liquidation value is too low and the value of the claims is too high. Now, suppose a company with 1,000 crores of claim, if a liquidation value is 50 crores, the adjudicating authority is asking, we need to understand where this 1,000 minus 50 has gone. If the RP has filed the transactional applications, and what is the amount that you have submitted there, and how much is the loss that the company has claimed. Now, in such cases where 1,000 crore is the total claims, and even this interest is not very high, let us even understand that the principal amount is 750, the liquidation value is 50, and the losses in the balance sheet is only 250. That clearly means that there is a gap of about 450 crores, and the adjudicating authority have started asking where this gap has gone and how the RP has seen it, whether the RP has filed any application under section 43, 45 or 66 or 49. These are also various questions which are coming when we submit resolution plans. I mean, there are many things that I can further add, but I think Mr. Madan, I have to just go by your direction that I will not take more than 10 minutes. I hope that I have already completed. Thank you. Thank you very much.
Thank you, but in these 10 minutes, you have raised more than 10 issues. That's fantastic. I just want to discuss one issue out of this, that the dissenting creditors, they are not getting their dues. Now, after this amendment and post Amit Metallics, what do you think should be the right position? What is the interpretation of the provision as well as the judgment?
Amit Metallics is also primarily has not attended this issue. What is the interpretation of section 53? I have read this judgment clearly. Section 53 has not been dealt with in Amit Metallic. In Amit Metallic, there are other factual difficulties. When Amit Metallic came to Honorable Supreme Court, at that time it has already passed 1 year from the approval of the resolution plan. Now, when some kind of case comes to Supreme Court where the resolution plan was passed a year before, and now somebody is claiming this dissenting creditor's rights. So what was the option available with the Honorable Supreme Court? Either to disturb the entire resolution process and do it again, or probably ignore that section 53 issue and say, okay, whatever has been given to you, that is okay. That is the, in case you would see this judgment clearly, that particular hearing happened before the Supreme Court after 1 year of the approval of the resolution plan. So that is not something which is attending to section 53. Rather, in the case of JP Infra, where the Anuj Jain was the RP, that has been a better judgment that you can't drag the dissenting creditor into a resolution plan, because in the resolution plan it was said that you would be getting these many flats. So the flats are not available today. The flats will come after the resolution plan is implemented after 3 years. Now, that means the ICICI Bank said that they are dragging us in the resolution plan.
Yeah. So I will just like to add here, because I have been the part of the COC in the JP Infratech, and this was not the issue which was not flagged during the COC meeting and when the resolution plan was actually considered. So ICICI Bank continuously, and we had from morning till night meetings on this particular issue, that what will be the treatment for the dissenting financial creditors, and ICICI has been flagging it throughout the process, and it has been actually put on hold or just not been, considered or something like that, and now it has been, kind of dragged into the court for so long now. So I don't know, again, how they are going to interpret the section 53 is very, very important, and in fact, it should be taken care while the resolution plans are discussed in the COC meetings. One should be aware of that, yeah.
What is your final word on dissenting financial creditors?
So definitely, I think I would say we have to consider it when, if actually the liquidation happens, we have to consider section 52 while we are deciding about section 53. So in the case of liquidation happens and the secured financial creditor has the right to, kind of hold its security and, kind of realize it and in section 52 and not being the part of the estate of liquidation estate in section 53, then definitely if we take that from there, they should be given their dues, like they should be able to have whatever security they have, say for example, given in the plan if they dissent at all. Yeah. Yeah.
Madanji, I'll just add one more thing. See, the very important that we have seen various orders where the resolution plans are being approved. I have to just see the format which has been given by Honorable President, what that format is. However, I think the most of the members have started saying that for this you go to this authority, for this you go to this authority, for this you go to this authority. So what I understand is section 53 is very powerful under IBC, and this is not under section 230, it is only under IBC. When we go for 230, there is nothing, no such waivers. See, section 230 is very clear in waterfall arrangement. If your water finishes at this level, thereafter everything is waived. This is regarding the financial claims. Like I am not saying, like when we talk about the income tax brought forward and setting of, as for the set of past losses, that is something for the future. When we say the RERA authorities will sanction my plan, that is for the future. So NCLT is not approving anything for future, but as far as the existing claims are concerned, everything should be finished if the money is not available. Even those kind of orders are not being passed.
Regarding this dissenting creditors, I would like to say this is becoming a very major impediment in approval of the plans. Yesterday, I got a call from ICICI Bank that now we have two options. Either to, consider for getting a liquidation value when the plan is approved as a dissenting creditor, or to get into the approval of plan. Yeah, all the creditors have these two options. If they consider this kind of option, plan will never get approved, because if it's below the liquidation value, or if one of the person has a secured, a priority of charge, then definitely this will become a major problem. So there needs to be clarity on this subject, and also mainly on the subject of priority of charges. This issue of priority of charges is needs to be decided upon, because there are conflicting judgments of NCLAT in this regard. So there needs to be a call from Supreme Court in this.
There is only one judgment so far. The NCLAT has given, in fact, because it is for NCLAT, once they have taken one view, which was taken by Justice Butt, now the NCLAT will have to follow that till the time the Supreme Court decides the other way. So in case any other bench also takes a different view, that means even the first judgment which was passed is kind of like overruled.
I think we are having now divergent views on dissenting financial creditors also, and I can assure you that every faculty member sitting here, every eminent speaker is willing to speak on this. I can understand Makija ji kaise chup baithe honge, I can understand. I think Abhishek also wanted to speak on this. He also picked up the mic a couple of times. This is an issue close to heart of everybody who's sitting over here. But I think it's very difficult to, otherwise we can speak for hours also on this particular issue. Now,
forfeit transactions are also something which is now it's being asked. If the transactions, if the applications are pending, the resolution plan should be approved or should not be approved. That also has actually been a very, very big issue. Now, the amended regulation says that the application has to be filed before, and the copy of the application has to be given to the RAs before even they file the resolution plan. This is the new regulation which says like this. So, for all the insolvency professionals, it is mandatory that right from the beginning they should work on the transaction audit and also prepare the IAs wherever it is required, and then pass on these copies of the IAs to the RAs. This is the requirement, latest requirement as per the regulations.
so though I want, but I'm keeping my remarks reserved on this. Yeah, Mr. Sunil Gupta, please now, your views.
Sir, thank you very much for the opportunity. And I think a lot of things has been already been told by Kohli Saab and Anilji. I'll just add 2 or 3 things into that. One is the power of COC members, which has been asked by all the circular by IBY, that the COC member who was coming, who was attending the COC meeting should have adequate power to decide. But in fact, they don't have, and they continue to be saying that we'll take the decision later on, let this come for the voting, and we'll decide. Even the resolution plan, they normally need to 15 to 20 days time to get the approval of their competent authorities in time, and that is a practical approach because ultimately their HOD's head office is deciding on the resolution plan. I think that to that extent there is some dichotomy in the process. Second is what Anilji said is regarding the funds. The provision of funds in any resolution plan, source of funds. Now, there is source of fund. I may say there is equity that I will be coming or the internal accruals that I will be generating during the process from the corporate debtor as well as from the resolution applicant, depending upon the timing of the payment. Now, the timing is not defined. Now, you may make the payment in 10 years, you may make the payment in 2 years. And if we see the NPV again is something which is a number. I may have a payment in 20 years with an NPV of 10,000 crores and payment in 1 year an NPV of 1,000 crores. With 20 years, the risk definitely increases multifold. So again, it's a problem where funds your sources have to be defined. Now, if I say a source, now if I have to give a source, again, there is a business plan which has to be supported by some Excel model and supported by the assumptions, past assumptions versus new assumptions. That has to be vetted by the COC members to check the viability of any plan. This is a challenge because in the plans, nobody is giving any projections. Only the projections of some numbers are given and as a part of the plan, but soft copy of the plans are not available. Secondly, the challenge of sources. For example, if I say I am having the capability of raising funds, then the problem is, should I get the sanction today? I am not aware whether this plan will be approved or not approved, and I am getting the source today, then this sanction goes out. And if there is a letter of comfort from the banks or any financial institution, we don't know to what extent it is valid.
They are non-committal almost.
Exactly. So they are a non-committed fund, source of fund, or any letter of comfort that anybody is giving, even the related party, if it is giving, we don't know whether it is going to happen or not. So definitely that is a big challenge for viability, checking a viability in any plan. Third is what we are finding in the plan is people are not aware exactly what to do, how to deal with the various liabilities. As we were telling about operational creditors, like I'll give you a very glaring example in which we were dealing. There were PF liabilities which were shown or gratuity provisions were shown in the balance sheet. Now the employee claims were not there. Absolutely no claims from employees were received, and gratuity is in any case has to be paid to the employees which are operating today. It's a tea estate where thousands and thousands of employees are working, and they have not submitted any claims because their current pay dues were paid, no gratuity dues were shown, and the gratuity dues were in the balance sheet. Now, effectively what happened that in the resolution applicants were aware of the fact, and that's why they provided some money towards the gratuity. Had it not been there, then that liability goes off. Now, how it to be dealt, it will be a big challenge. So people are not aware of how to deal with these types of subjects in the plans. One more thing which I would like to add, the challenge in a resolution plan is, or during the CRP process, is the lack of knowledge by the civic authorities or the police. Now, if I have to take a possession of a thing, if an asset and CD is not helping me, one option is that I should go to for 19(2) and get a possession, or I should ask that the civic authorities may be asked to get the possession or help me in getting this possession. Now, if I go to the police, he says, okay, fine, get me the order in my name only, then I'm otherwise just keep this order aside. I'm not entering into this. And and then there is a loss of time. Important is, one is the NCLT is burdened with the new applications, and secondly, there is a loss of time. And considering the time factor that we are already struggling with because of the various challenges as we have discussed during the entire course of day. So time management becomes very difficult for any RP to meet those timelines. Then litigations, definitely we have discussed the litigations. We have also found the agitations, post-approval agitations by workmen particularly, because for workmen, normally people are not keeping. Now, that is where I think the regulators or the lawmakers have to see, if we have to secure the interest of a workman, then workmen have to be given priority, and the entire amount should be given rather than a portion of that, because they say that they are pari passu with the secured creditors. Now secured creditors may be getting 20% and they are happy with it. But for workmen, it is a lifeline for them. And I think this is my personal view that they should be protected. Either should be protected or should be then because resolution applicant who is a successful resolution applicant should not be debarred from taking over the asset and operating the way he has been approved, the plan has been approved.
I think at that stage, the resolution professional should convince the COC as well as the resolution applicant, at least workers' dues should be taken care of.
Sir, I agree, but the thing is that we cannot force. As an RP, we cannot
I'm not
force.
saying force, but he should try to convince both.
Exactly.
The parties,
The point is that sometimes the magnitude is quite high. I can tell you in one of our cases, we got workers' claim of 5,000 crores. So there were 14,000 workers and we got 40,000 workers claims were received. And the claim was 5,400 crores. Now the plan was only 375.
Were they working without wages with the corporate debtor?
No, whatever you say, no, that is a different issue because that claim was rejected because they were not supported. But my point is the agitation may happen once the resolution plan is approved. Because it's T estate and T estate, you know, okay, there is 4,000 to 5,000 workers which are working in each T estate. So these are the problems challenges that
I'm
we
just
have
raising a
faced.
question to you. Mr. Anil will raise a question of this feasibility, viability, funding arrangement and business plan and attending to the cause of default. Should it be kept to the jurisdiction of COC or should the adjudicating authority look into all these aspects?
Sir, my view is COC should look into it. But the thing, in any case, the viability has to be checked by COC. Now, problem is that because of the lack of information, first is because there is no format. I think the format has to be devised and format has to be given to the RS. That this format is given and this is the minimum information that you have to provide. The cause of default, one of the reason, and a lot of people are saying the cause of default is there. But even the RP doesn't know what is the cause of default. Now, how can you assume that the cause of default is normally what we are saying, as Mr. Anil was saying, that for 2 years we can, in the plan, in the code, it is the look back period is 1 year or 2 years as the case may be. Now, the inventory is overstated for last 15 years. How can you go 15 years back? You are not allowed to go to 15 years back. So what you are saying is, it is the prerogative of COC to see the viability of the plan, but there should be adequate information which should come into the plan so that the viability can be checked. And that's why it can be recorded in the minutes, yes, we have checked the viability. Maybe in the second minutes, later on, once the plan has been discussed, maybe later on they can internally check and then they can come up in another meeting and they can say, yes, the plans are viable. These plans
My request to why don't you devise a format and give it to IBBA so that IBBA come out with the regulations
I think, sir, we will be very happy to provide some.
Please do that. We can all help you out and we can go to IBBA.
Sure, sir. I'll discuss with you.
Thank you. Thank you so
sir.
much.
Thank you very much.
Thank you. Now I'm going to reverse the role. Before coming to section 230, whatever the issues have been raised, couple of issues I'm going to raise to the other co-panelists who have not been part of this program so far. Makhija Saab, Mr. Anil Kohli raised an issue of this filing of these, not filing application with the adjudicating authority, but it should be to the board. So you know you are wearing two hats, as advocate as well as insolvency professional. What are your views on this?
Okay, see, as far as the status reports are concerned, particularly in liquidation, now we are talking about preliminary reports and the quarterly reports. Let's understand, adjudicating authority is the supervising authority. There is no COC. Stakeholders committee, of course it is there, their roles have been increased over a period of time, but they don't have any, they have only recommendatory powers. So at the end of the day, the liquidators are kind of reporting to the adjudicating authority. And this is the same scheme which is following from the Companies Act. Because in winding up, the official liquidator who was there, now he was always asked to file a status report before the next date of hearing. So filing of a status report to the court is not an empty formality, friends. It is something which is serious, because it will also protect the liquidators also. Because if you have already covered something, probably you might not have filed an application, but you have covered something, I think it will protect you in times to come. So in my opinion, I differ with Mr. Kohli. I would say that let it go there, because it's at the end of the day what the courts are saying. I mean, the adjudicating authority in most of the cases, they say we take it on record subject to just exceptions, because that's their job to do it. Now, whether it is filed as a part of the application or just like a status report, I think they are following the judicial process. In the High Court also, they were a part of the application only. We had to file as an application only. Otherwise, registry cannot recognize it. Number has to be given. Unless the rules are changed, as Madan Sahab said, unless you change NCLT rules, well, this is the process which you must follow.
The issue is, actually, I forgot I'm sitting between the lawyers, you know.
Both of us are IPs also.
Major issue is
Now, Anju, Anju, I'm going to raise a very tough question to you. Mr. Anil Goyal said that plan has to be in compliance with Section 30, subsection 2. And all of us have gone through the recent Supreme Court judgment of Rainbow Papers. If statutory dues, government dues, any legal authority dues, or any other authorities dues, if they are not part of the plan, this plan is not in compliance with Section 30, subsection 2. So what is your take from on the times which are going to come now, wherever the plans are already before the adjudicating authority, already before COC, or the plans which are going to be submitted? Do you think that this issue can be dealt with in the resolution plans, and all those plans where the dues have not been provided, they should be treated as non-compliance of 30 subsection 2?
Yeah, so I think for me, like after this rainbow judgment came, main issue is the treatment for the operational creditors who are not sitting in the COC, first of all. Because what is happening, and it is from the day one, in fact, after like IBC came and we were seeing some resolution plans and where the operational creditors were not getting their dues. So I will come later on the statutory dues. I will first, handle the issue of this operational creditors who are not coming in the COCs, and COCs are not taking care of their, I would say, interest. They are not protecting their interest in the sense because they are voting on the plans. So from the day when I'm saying that even if the financial institutions are required to take their money back to be or to remain solvent and do not go into bankruptcy, same goes for the operational creditor. And I think today only in the very beginning, in the first session, I don't know who said that MSMEs, which is the backbone of the economy, who are the operational creditors to these corporate debtors who are going into insolvencies. Like we saw the largest 12 big cases coming up, where I'm sure at least, if not less, 100 or 200 MSMEs who are, providing them support services and goods and services, sorry. So it is very, very important to make them relevant and to make them solvent, that their rights or their interests should be protected in the COCs. Now then comes the treatment to the statutory dues. So my humble submission has always been there, and as RP, I have tried to convince my, at least COCs, that if not, given them their everything or a major proportion, at least something should be given. So if something is given, definitely they have been dealt with, means the debt has been dealt with. And in the going forward, if we kind of resolution, when we are talking about resolution plans, and we are talking about the Section 53's application in the resolution plans also. So then those have been already been dealt with in Section 53. So statutory dues, operational creditors dues, if the code or the BLRC committee or the makers of the law have already put them somewhere in the Section 53. So why we have to, kind of bring that together again and again. In fact, more than the statutory dues, we need to take care of the operational creditors who are not sitting in the COC, who are small business owners and who are very, very relevant for the economy per se, as a developing economy. So definitely this rainbow paper, because in the rainbow paper issue is not only this one, because the lead banker actually had called me, who was there in this case, and the plan has been contravened. He has already demerged the entity into their own entity, and they have sold the assets of the demerged entity then. So there are so many issues in rainbow, and not all the parties were there in the Supreme Court judgment in any case. So not all the stakeholders were represented there in any case. So there, I think it will be opening a Pandora box. One more aspect which I saw as an entrepreneur, as a resolution professional, at the garb of not providing to operational creditors, none of the stakeholders actually getting benefited from the resolution plans. The only one person getting benefited is the resolution applicant, because then at the garb of the law or at the garb of the the provisions, he can actually extinguish all the debts, and good assets have been bought in exchange of peanuts, I would say. So there we have to be very mindful as resolution professionals and COCs that what the inherent value in the corporate debtor, and accordingly the price should be determined for the corporate debtor, and the plans which are actually providing for that inherent value should only be kind of approved. Otherwise, in any case, we have liquidation. So in 53, everything would be settled. Yeah, thank you.
Does it mean, just a minute, sir, just a minute. What you're trying to say, sir, just a minute, please. Just a minute, sir, just a minute. Okay. Okay. If the government dues, according to the government dues, have already been dealt with in 53, they are almost at the bottom. Does it mean they cannot be now considered as secured creditors under 53 and be at top of the board, as has been done in Rainbow?
Yeah, so secured creditor will come in the section 53
No.
in priority, no?
Court said they shall be treated as secured creditors, while 53 said they will be at bottom of the board. Yes, Abhishek, you want to?
Yeah, so they have created a lead.
I've opened a Pandora box. I
No,
know.
you have. In fact, if we see the judgment in Rainbow, the question is framed in para 2, that whether the Gujarat VAT Act
yeah.
will make them a secured creditor or not. So we can't generalize to say, but if we look at any of the acts, whether Himachal Pradesh, whether the VAT Act, everyone have the same provision.
No, but I think if you read, sir, para 53 or 54,
No, I'm
which
coming
is
to
a very
that.
draconian one.
51, 52 and 53.
Yeah.
If you read that, it says...
This company has to be liquidated if you are providing for that.
Adjudicating authority has bound to reject the resolution
Yes.
plan, which does not take into account the dues.
Dues, yes.
But ultimately we'll have to see whether the question framed in para 2 and answered subsequently has to be seen, and the rest of the judgment, the directions are per
तो
incuriam.
इसका लेके 5% दे दो और वो चल जाएगा. It will be due compliance.
It has to be taken into account whether they are a secured creditor. The question was whether they are a secured creditor,
Yes.
how the treatment is to be given in a plan to a secured creditor. But while doing that in para 51 and 52, they have said that the dues are to be taken into an account in the resolution plan. But if they are not, and you are right, those three words, that government dues, legal authority or any other state government authority, and if they are not taken into account in the resolution plan, the adjudicating authority is bound to reject the plan. Now that will create a situation, and in fact it has already in various benches. They have issued an order saying RP to file an affidavit that the resolution plan, which was heard orders reserved, now to file an affidavit and say it is in compliance of Rainbow judgment. So we are in fact waiting that the review come next week or a week thereafter.
Aji, we need to consider it as this judgment of passed in Supreme Court in civil appeal and not under Article 142.
That's right.
Yeah.
No, but sir, in fact, if we read the earlier judgment, which came 2 weeks before it,
Yeah.
which was the judgment in ABG Shipyard,
ABG Shipyard, yeah.
same argument under the Customs Act, which is have a paramateria section 11A, was taken, and it is a 3-member bench judgment. This argument of overriding effect was negated. They were treated to be an unsecured creditor, and subsequently a judgment has come which has now created an issue, given I would say a dark rainbow in all resolution plans going forward.
We can't forget Ghanshyam Mishra also.
No, but Mr. Madan, you have to give me permission.
Sir, मैं आपके पास ही आ रहा हूँ मैं. You कह रहे you have to give me permission. आपने कभी ऐसा देखा है? You have to give me permission. बोलो I'm seeking your permission. You have to give me permission. फिर तो मेरा option ही कोई नहीं sir please.
So I just want that the audience, the attention is invited to paragraph 5 of this judgment. And paragraph 5 of this judgment actually is revealing 2-3 facts which are very important. One, that the particular tax dues were pertaining to year 11-12. Second, in 2016, the recovery proceedings started. Third, that in 2018, the assets were attached by an action of the department. When we have assets as attached by way of an action by the department, then we go to the definition of security interest under IBC. Certainly, if an asset is attached, that is also considered as the security interest. And once the security interest is established, then we go to section 53, because the wording there is secured creditor in the first row, after the CIRP and the liquidation cost. The secured creditor means any kind of secured creditor, may it be financial or operational. This is what I wanted to add. This is what I wanted to add.
Okay, that's your view, sir. Because as I said, I have opened Pandora box, and everybody is having his views on
This is a
this.
different fact, and it cannot be generalized, to my understanding.
Okay. Saurabh, Goyal साहब ने एक और issue raise किया था, objections to the plan. And sometimes we see that some of the creditors who are members of the COC, they abstain from voting. And then they file objections to the plan. Should such creditors be allowed to file objections to the plan unless they have voted against the plan at the time of voting?
Well, I think it's a very pertinent question, Madan Sahab. And I think, as you said, that the law, as far as that issue is concerned, I think is well established, which is one part is the commercial wisdom of the COC. And the others is with respect to dissenting. Of course, there's so much of things to say as far as dissenting creditors are concerned. But I'll take it that way directly itself, because ultimately we have to go at the threshold 66%. That's the law, which is mandated under the code. So as long as, of course, so I think the law there is absolutely clear, which is compliance of the code, section 30, which comes into play. As long as it is in compliance, the plan has to be approved. Yes, but many times, so I really don't think so that there is much scope unless somebody is able to show that the plan is contrary to law or not in compliance with the code, that they will be able to show that whether it affects them directly or whether probably some part of the plan is not in support of them, or maybe there's some part of the plan which probably doesn't suit them. I don't think so that's the intent of the code, number one. And I don't think so that's the commercial wisdom of the COC as well. And I don't think so at that stage, as long as the adjudicating authority consider these 2 points and these 2 issues, that there is much scope as far as interference is concerned. And of course, there has been some judgments to that effect where some part of the plans have been interfered, or maybe there are certain comments with respect to that. But in law, if you ask me, or what probably the intent of the law is concerned, or what probably the commercial wisdom comes into play, there's not much scope as far as those issues are concerned. Yes, there is an issue with respect to abstain. I don't think so there is anybody who would try and not probably in future would like to take benefit that I have not probably voted against it, or I have voted or not, probably I have abstained. I don't think so that benefit would accrue to any one of them, and especially in some cases which we have seen before the adjudicating authority to financial institutions. Now that kind of practice, I don't think so. Probably we would have much leeway to go about it.
Thank you. Makhija Sahab, now I come to section 230. Sir, there is a provision in the code that in case of liquidation, after the passage of this liquidation commencement order, there is a provision under section 230 of Companies Act 2013 that a scheme of compromise or arrangement may be given. There was no clarity in law who may submit this scheme, at what time the scheme should be submitted, whether promoters can submit this scheme or not. Then we had in the year 2021 only, I think, or in the 2020, Amit Gupta and S. Dhanpal and all that cases, where the liquidators were actually directed to have such an arrangement for the acceptance of those schemes. They should wait for 90 days from the date of passing of the order. It was also said that 29A will not be applicable to the promoters, and the promoters of the corporate debtor can also submit that scheme. Later on then came Arun Kumar Jagatramka versus Gujarat NRE Coc, where it was reversed that the promoters who are ineligible under 29A, they cannot submit a scheme under section 230. And then we saw the amendments in the regulations also. Now, according to you, sir, what exactly is the status that who can submit a scheme? Can it be from the creditors only or shareholders only or combination of them? Or any outside party can also submit a scheme? Because recently we have seen some of the newspaper advertisements are coming from the liquidator that anybody and everybody on this earth can submit a scheme under section 230. Is that permissible, sir?
Okay, I think Madan sir, you have raised a very important issue. See, in my opinion, insofar as section 230 is concerned, now it talks about compromise and arrangement under Companies Act. And we have to follow the law which is mentioned in 230. And in 230, there are clear words which are used, creditor, member, or in case of the company which is under winding up, liquidation under IBC also, because those words were added later on. So it can be filed through liquidator. So these are the three words which have been used. Now, coming on to this aspect, because there are some judgments, the reliance is being placed on some judgments to say that only liquidator can file. Well, I do not think that, number one, those judgments are really on that issue. That's number one. Number two, in fact, there is another NCLAT judgment which says even the promoters can also file, provided they are qualified under 29A. Of course, that is to be there, but it can be filed by a shareholder, member, or a creditor also, any creditor. Now, one thing which you asked, that if the liquidator is publishing an advertisement, public announcement, inviting 230 from everyone, this is absolutely wrong. This cannot be done. In fact, I have seen certain advertisements which clearly restrict that to the members, creditors, or to these people only. I think that is the correct way of looking at it. Now, one of the important aspects which is there, let's understand what is 230 and why it has been brought in. Well, it's a laudable step. Whether 2B was there or not, according to me, still you could have filed it, whether even Dhanpal was there or whether Amit Gupta was there. Or Amit Gupta was in January 2019, Dhanpal was in February 2019, not in 2020. So 2019. And later on, of course, 2B was brought in. But let's go back to the Companies Act, 56 and 2013. Now, in my experience as the standing counsel for the official liquidator, where we, handled all these things, now the schemes were being filed under 230 in companies which were winding up, There was no time limit. You could come after even 10 years also and you can say, look, I want to take over the company because this is a compromise or arrangement scheme. The courts were not prohibiting. They said, okay, you file it, we will call the meeting. Once it is approved, we'll see whether your scheme is valid or not. So this is the same process I think we'll need to adopt here. And number two, under Companies Act, not one judgment, there are a number of judgments. And in fact, that has also been taken care of in NCLAT judgment in Amar Dicam. And they are relied upon Megal Homes, which says besides the liquidator, because unfortunately where the confusion is coming. In 230, the word is that in case the company is under liquidation, liquidator will file. So then people say, oh, now the members and the creditors cannot file. No, that's not the correct view. Because if we look at Megal Homes, which is a landmark judgment of Supreme Court, under Companies Act 56, and the same principle will apply. Because the language of 391 and 230 is absolutely pari materia. There is no difference. And that has been recognized in Amar Dicam's judgment of NCLAT, which says besides liquidator, members or creditors can also file it. So therefore, to say that only liquidator will file it, that is not the correct view. But there is one more technical aspect. Fine, scheme can come from members, creditors, and they should file it to the liquidator under Rule 2B, Regulation 2B. Now, who is going to approach the NCLT? Should only liquidator approach, or can the promoters or whatever members can approach directly? Now, this issue is not decided, but according to me, as in Gujarat, NRE Coc also, and in many other judgments, the promoters directly filed. Well, they have to be qualified under 29A first, that's an important issue. But if they are qualified, can they straight away approach? I think this question is yet to be decided by any NCLT or NCLAT. But right now, the view which is coming is that it should be through liquidator, but I do not subscribe to that view. Because according to me, even a person can approach directly. Of course, copy has to be given to the liquidator, and liquidator can examine that. And if he finds any problems are there, eligibility criteria, I think he can have that word.
Thank you. But I think, sir, it should be allowed to anybody. Reason being, under 12A also, if you see 12A read with regulation 30A, that a settlement or withdrawal application can be filed either by IRP or RP. But in number of cases, we have seen even the promoters or parties to the settlement, they are also filing an application under Rule 11. And those applications are also being accepted subject to that you have paid the CIRP cost. Whatever the IRP or RP dues are there, other cost has been paid, so they are being allowed. And there are divergent decisions on this of Honorable NCLAT also. So here also I think it should be, what is the objective? Objective is settlement, whether A files or B files or C files. Let's not go by the exact language of the law. To the extent the objective of the law is being achieved, I think even the member or creditor should also be allowed to file it. This is my personal view.
As I mentioned, members and creditors are already allowed under 230, but you are saying outsiders.
Outside.
Now, well, you see, I'll tell you, then you will have...
Outsiders I'll not. Outsiders I cannot submit a scheme also, that's what
Yeah, then you should, you are basically saying that 230 should be amended, because if you read it says compromise between the members and creditors.
Yes.
So if it is between the members and creditors and shareholders, the compromise can happen only between these interested parties. It can't be with an outsider.
Compromise. The word is compromise or arrangement.
Or
It cannot be
arrangement.
with a third party.
Correct.
That's a
Then it's a resolution plan.
That's a fresh proposal. Yes,
That's a
that's a
resolution
fresh
plan.
proposal only. Okay, now next question to you. Being an insolvency professional liquidator, now according to me, I think I may be wrong, please correct me. There are same timelines for two activities post liquidation order. One is to sell the company as a going concern within first 90 days, attempt should be made. Another is to find out a scheme of compromise arrangement again within the same period of 90 days. So how to synchronize or have a harmonious construction of these two?
It's a very good question, actually, and in fact, I have been, I would say, struggling with this in one of my liquidation cases, and Abhishek is the, kind of proof of that, means he's been handling me in that case. I will just, before answering your question, I will just go back in time in the sense like what Mr. Makhija has talked about in the 230 scheme and arrangement. So definitely, I think one is that settled position that only the members or creditors or stakeholders should be allowed for the scheme. Also for the purpose, one, that it is already there in the Act, in the Companies Act. Two, for the simple reason that it is about a company's confidential information. So if you are allowed anybody outside of the kind of ecosystem of the company, then definitely you are putting the corporate debtor to some risk of any pilferages and something like that. So technically it cannot be done. And now, in fact, when the liquidation regulations has been amended already, and the scheme has to be completed within the initial 30 days of the order of the liquidation. So how will you pass on the information to any outsider? And in this time frame, it is not it's not practically or imaginably possible to have anybody, coming in those 30 days and having the information about the company and, tabling a scheme or propounding a scheme and then getting it approved from the stakeholders. So it is not practically possible. So that question goes away. Now, here comes a very pertinent question. What should be the scheme itself first to be considered by the creditors or the stakeholders? Can any piece of paper be considered or propounded, be taken as a scheme? Because in one of my cases, I'm struggling with with this particular pertinent question, and 15 months in the liquidation already have been passed, and the case has been dragged along from the promoters, from 1.5% of the stakeholder, who's been taken on toss of all the creditors from the long time, that in fact the scheme, section 230 clearly says what a scheme should look like what all are the mandatory requirements of the scheme to be tabled. It has to come with the consent of 75% of secured financial creditors. So if that is not there, like with other things like the valuation, the audited books of accounts or the balance sheets and other things like whatever is listed there. So can any paper be considered as a scheme of arrangement or a compromise or not? So in my views, definitely, if the scheme or this plan or whatever you call it is not coming with all the mandatory requirements, it cannot be accepted as a scheme. Now, second question comes to the 29A eligibility, which you definitely dealt.
question I'm going to reserve for Sora.
Okay, fine. Sure. So then if there is anything left there, I would definitely add on there. So 29A eligibility is does come here as well. And what will then be, kind of taken as 29A eligibility? Let's sort of speak about that. Now I have forgotten what was your question to me exactly.
What is to be done post liquidation?
Yeah. So the earlier, I understood. So earlier was the regulation was such that the compromise of arrangement also and the going concern also should be considered in the first 90 days. And there was definitely a gray area or lacuna in the clarity of the regulations that which should be the taken or considered. In that sense, if COC, while in the last meeting of its kind of passing a resolution for something, say for example, whether it is a compromise of arrangement or whether it is a company selling it as a going concern or anything. So I think the RP, who is becoming the now liquidator, that RP was there in the COC and now coming as a liquidator in the liquidation, definitely will go by what the COC's past resolution was there. So definitely first RP, who's now becoming the liquidator, and in fact, even the liquidator is a changed person. He has to consider the minutes of the COC, where the decision for liquidation has been taken amongst the secured financial creditors or the COC members. So definitely when then there is no, there is a clear agenda passed in the COC minutes, then definitely RP or the liquidator has to take care of that. But in the case when the liquidation is happening, like say for example, suo motu, there was no resolution passed in the last COC meeting, or liquidation is happening because of contravention of the plan or plan not getting approved and there was no CIRP left to take any decision like from the COC, then definitely these two things might go together. But now I think we already have that clarity in the changed regulations. So going concern should be the first, say for example, and in any case now a scheme being kind of completed in first 30 days and going concern auction cannot be put in the first 30 days. So I think it is very, very clear if in the first 30 days though no scheme has been kind of considered, then definitely the company can go into first liquidation. Means the liquidator should go at least in the first e-auction, should go for the going concern, and subsequent if that is not kind of successful, that auction is not successful, should go for the asset sale. So I think my limited view is that.
Thank you. Now the time is running out. Saurabh, last question to you. Earlier, Section 29A was not applicable in case of scheme by promoters, scheme under Section 230 of the Companies Act. Then we had this judgment of Arun Kumar Jagatramka versus Gujarat and Coc, and then we saw the amendments in the regulations. And can you believe that Mr. Arun Kumar Jagatramka has written a book also on this? Yes, he has written also with how he has been treated in this entire CIRP process and liquidation process. What is your view that because under 12A, if a settlement can be given by the promoters only, so whether similar provisions should not be extended here or promoters should be allowed to give a scheme under 230?
Also attracts 29A.
No.
Well, I think, so I believe, I think this has to be read because 391A, or whether you talk about mega loans as Akija said, or you take it the same paramateria 230 in terms of the schemes, and then you take them and apply them in a provision of a liquidation under IBC. The intent as the law which provides when 29A came into picture in terms of the plans under the code, and when you talk about liquidation and you talk about same and read within paramateria 230 of the Act, but I believe that 29A, I think, is simpliciter, is completely comes into picture. In my view, of course, and as you said that in NRE Coke and Jagrama cases, the Supreme Court has clearly said, relying on the Megal Holmes concept and as well as the concept even under Swiss ribbons to say that liquidation, even under liquidation, you always try and put the company as a going concern. And that was the intent which brought in even in that judgment also. But 29A, when you talk about, I think as far as even the judgment also of the Supreme Court, even the subsequent judgment in Pawan Bildwell or other several judgments, even of the NCLAT also has clearly held the same, that as far as 29A is concerned, 230 probably there's a bar. And the intent probably behind that, for the purposes of bringing a scheme ultimately is the same what we had earlier when 29A's constitutional validity came in and all those issues were dealt with by the Supreme Court. So same issues comes in even in under the process of liquidation as well. Yes, only one exception, as you said, that what happens, of course, that all right, maybe in several CIRP processes we have seen that there are always changed circumstances, and that's how even 12A was brought in. When Rule 11 was canvassed by the Supreme Court, and then 12A was brought in to say that what stage settlement could take place. And this is one of the scenarios, as you said, also observe that because in every CIRP there could be processes where even some of the CIRP we have seen EOIs, there are no plans, the promoters are simultaneously trying to settle. And then what happens when suddenly an order of liquidation passed, that whether it can come at that stage. Yes, if you ask me and see the intent of 12A or 11, it can come, but in principally, the code really bars that process as well. The only exception to is 230, which is of course, is an exception which is otherwise also considering 29A, not otherwise. So I think there the law is absolutely clear. Of course, we are still, I would always say as far as IBC is concerned, 6 years is always a nascent stage, and that's Rainbow is an example of that to an extent. And some of the other Vidarbha, we had so many other judgments, but maybe time tested, because in my view, I think 230 is not really tested as of now, frankly, if you ask me. It's neither the regulations, as you said, issues raised with respect to time frame. I think there is something which is required to be done if you want to promulgate or probably, raise the issues of 230 in the liquidation. I think much is required to be done under law as well as under the rules and regulations for somebody as a liquidator to, raise the issues of 230 at that stage.
I really like this term, the law is at nascent stage. Everybody using this term. But when it comes to IPs, then law is not at the nascent stage. He is supposed to be super expert.
Can I just make a comment on that? Please, because I am an exception, I'm not an IP, so I can always make that comment. Well, I think he is absolutely right to an extent. I think much has been said, and many times these issues comes to me also in several forums that what happens when IP has acted in a particular manner. Of course, we always talk about IP sitting at the top at the helm of affairs as a rainmaker, as I always say, one who's always trying to bring everything and the best of the things for everyone, of course, with a commitment. I always say that as a rainmaker, that he acts as an IP. But yes, I think some of the issues which have been raised or some of the things which has come from the regulators, frankly, much to be desired of. And frankly, there are always extraneous circumstances, because right from, I think we had seen some of the orders which has come in from 2006-17, and now what we are seeing, and there are exceptions to that. I think there's much to be said as far as those issues are concerned. And I think we have to take a larger picture to that aspect rather than going into maybe standardized or generalized principles, which otherwise also in future has changed, if I can say so.
Yeah, just a brief. So there's a basic difference in 12A and 230, because 230 is a compromise and there is a kind of haircut which has been given to the creditors, whereas not in the 12A, so they cannot be put together, one thing. And for the 29A check, there is very, very important aspect which needs to be seen by the courts or when the 230 scheme is being propounded. That if the company has been taken into insolvency in the section 10 only, and before the section 10 application also the company was in the last 4 years in the BFIR. So after the 4 or 5 years in the procedure in the CIRP and the liquidation, can one fine day 1% or 1.5% stakeholder come up and say that I want to file the 230 scheme, who's the son of the MD of the company who made the company to this level? So I think these aspects has to be seen into in conjunction with everything together, because even if the 29A applicability is there in 230, so one more aspect that the only 230 like the aspect of 29A is not seen in the case of MSME, and if the company is not the MSME, and even if the written down value of the assets or the investment in plant and machinery has been there, still you cannot be an MSME in just because there has been some judgment in some other case who has been given if you are eligible to be. So the eligibility for MSMEs also has to be seen into, you know, kind of into a 360-degree view, and not just one judgment should be precedented to any other case. So every case has to be seen case-to-case basis, and then only the jurisprudence should come. So that's my limit. Thank you.
Take a note of subject to just exceptions. Over to you, my dear Abhishek. Thank you very much, everybody. Thank you.
Thank you, everyone. I hope that we have not kept you too long waiting from the lunch. And from this session, I think that we still have the Pandora box open, and we still need to get the answers, I think, sooner or later, once these judgments probably, which we were discussing today, comes to, I think, a review or probably settle down. And I think the issues of 29A will still go on. And I would say, take the comment of Saurabh that it's at the nascent state. I would say it will still go on till the IBC is going on. So it can't finish.
Thank God you are saying till the IBC is going on.
Yeah. So 230 scheme, when there was no 29A only. So that is what got envisaged.
So
29A came only in IBC.
that's right. So in fact, I will not dwell upon any of the issues raised. I am just now.
Yes, please. There is solvent company. तो फिर liquidation में क्या कर रही है वो?
But there is some dispute between the applicant and the CD. Dispute or not on record, so it may be admitted also. Can the COC decide after formation of COC that settlement plan with the promoters without going in through CRB process?
Okay, the section 12A is applicable because 12A also allows that even 90% of the committee members, in case they agree to take 50% or 40% or 90% of their claims, still 12A is possible. However, in 12A, only the creditors who agree to this, other than the 10%, because he will be dragged in, all other operational creditors and no other liability would be waived. With the company will just only 12A means the CIRP is withdrawn, and it will not be considered as section 53 is not applicable on 12A. So no other waiver, no other operational creditor, no government authorities would be waived because it's just a withdrawal. It's just a withdrawal. So the COC can decide 12A at any kind of haircut, but that doesn't mean that other applicable provisions would also act here in this case. It will not, because no other waiver would be there.
There is no haircut in this proposal. We just want to pay the.
Well, sir, lunch पे करते हैं ना discuss please. हाँ, खाना खाते हुए.
So I thank everyone, and please join us for the lunch.
If you permit me, there is a query from my side.
Dr. Jatinder.
Yes, Dr. Singh.
Thank you very much. In fact, let's have a big round of applause for all the panelists. And special thanks to Mr. Madan for moderating the session. So I was just sitting there, I was feeling he was just not a moderator, but also devil's advocate, right? Because he was just provoking everybody to, come out with some of the novel ideas and solutions. Thank you very much for this indeed. And I will request Mr. Madan and Mr. Abhishek to kindly come forward and please felicitate our panelists with a small token of gratitude from PhD Chamber. Thank you, everybody. And ladies and gentlemen, in fact, we'll be coming out with the report of this conference with all list of recommendations. We will send it to you also once the report is completed, and we definitely look for some of the recommendations from your side also. Thank you very much. Thank you, India.